Welcome to Clue, Criminal Law for UK Enforcement. What is the definition of assault? What are the points to prove? Most people think assault means punching someone, but legally, you can be guilty of assault without ever laying a finger. That's right, even raising a fist or shouting threats could land you in court. In this video, we break down what the law actually says about assault, what counts, what doesn't, and how it all works in real life. So, let's begin by answering what is assault. The legal definition of assault is intentionally or recklessly causing another to apprehend immediate and unlawful violence. This means the victim must fear that force is about to be used, even if it never happens. Assault can be words, actions, or both, as long as the act creates fear of harm. We've defined assault as intentionally or recklessly causing another to apprehend immediate and unlawful violence. But what do those words really mean? Let's break it down, one term at a time, so you understand exactly what the law is saying and how it applies in real life. Intentionally means you meant to make someone feel afraid of violence. You wanted that reaction, even if you didn't plan to follow through. Example, you raise your fist to scare someone. You never planned to hit them, but you intended to make them think you might. That's assault under the law. Recklessly means you didn't mean to scare someone, but you knew your actions might, and you carried on anyway. Example, you throw a glass bottle over your shoulder without looking. The bottle narrowly misses a bystander, who is shocked and shaken by the act. You didn't mean harm, but you ignored the risk they'd feel threatened. That can still count as assault. Apprehend. To apprehend means to expect or fear violence, not to be hurt. Assault doesn't require physical contact. If someone believes you're about to hurt them, even if you don't, that can still be assault. It's the fear you cause that matters, not whether you follow through. Immediate means the threat must feel imminent, like it could happen right now. Example, saying "I'll hit you next week" isn't assault, but "I'm going to hit you right now" while raising a fist is. The person must feel danger is present and about to happen for it to count as assault. And finally, unlawful violence. Unlawful violence means violence not legally justified, like in self-defense or arrest. Example, a police officer lawfully restraining someone isn't assault. But threatening violence outside of the law, with no excuse, this is unjustified and therefore unlawful violence. Not all assaults are the same. Now that we know the definition of assault, let's have a look at the different levels of assault. There are 4 different types of assault, and each one carries a different legal meaning and punishment. Common assault, fear or minor force. Battery, physical contact. ABH, actual bodily harm. GBH, grievous bodily harm. Let's break down what each one really means. Let's begin with what is common assault. Common assault is the lowest level offence. It includes both assault and battery. This covers minor force or fear of force without lasting injury, like grabbing a wrist or shouting threats in someone's face. It's still serious and can result in charges even without visible harm. ABH, a step up in harm. ABH means actual bodily harm, defined under Section 47 of the Offences Against the Person Act, 1861. It applies when there's more than minor harm, such as bruising, cuts, or shock. The injury doesn't have to be permanent, but it must be more than just fear or slight pain. GBH, the most serious form of assault. GBH stands for grievous bodily harm, serious injury like broken bones, stab wounds, or long-term trauma. It can be charged under Section 20, reckless, or Section 18, intentional, of the 1861 Act. What is the difference? Section 18, intent, carries a much tougher maximum sentence than Section 20. but both are extremely serious on the assault scale. But what actually makes an assault worse? That's where aggravating factors come in. These are things that make the offense more serious in the eyes of the court. For example, if the victim is vulnerable, it was a repeat attack, use of a weapon happened in front of children, driven by hate like racism, homophobia, or religious bias, these can lead to a tougher sentence in the eyes of the court. What can be a defense to assault? Well, it depends, but here are a few examples. Self-defense, if you used reasonable force to protect yourself or someone else. Consent, like in contact sports. Accident, where there was no intent or recklessness. Or a genuine mistake. Thought it was a friend play fighting. Whether these hold up in court depends on the facts, the context, and your actions. Case law, R versus Ireland, 1997, when silence becomes assault. In R versus Ireland, the defendant made silent phone calls to women. The victims were terrified. The court held that silence can still cause fear of immediate violence, meaning it can be assault. This case expanded how courts interpret assault, not just actions, but also what is heard, or not. Recap. Assault isn't just about throwing punches. It can start with words, gestures, even silence. What matters is fear, intent, and harm. From common assault to GBH, the law looks at what happened, why, and how bad it was. Know your rights, understand the defenses, and remember, even a shove or a threat can land you in court. If this helped, give it a like and hit the subscribe button. Stay tuned for more videos. Keep learning, keep overstanding. Know the law, understand the offense. See you next time. Thanks for watching. If there's a legal topic you'd like us to break down, drop a line in the comment section below. We're here to make the law clear, practical, and easy to understand.